teams. If you all give us just another couple minutes, we're going to we'll get started in just a few. Thank you. All right, everyone set? Okay. Let's see. I lost my... There we go. Okay. Good morning, everyone. It is 9:03 a.m. This is a regularly scheduled board meeting of the Real Estate Appraisers Commission. And we are going to get started here. We're going to have a call to order with a roll call and then move into the agenda.
This meeting is being recorded and or transcribed.
That was helpful.
We'll do roll call.
Okay, thank you. Actually, could you go? I think we missed that. Would you go ahead and give us the call to order?
We'll call the meeting to order. Let's go ahead and do roll call.
All right, thank you. Ms. Alexander.
Here.
Mr. Bennett.
Here.
Mr. Atwood. Mr. Garrison.
Here.
Mr. Mansfield.
Here.
Ms. Haston. Ms. Cole. Cole is absent. Dr. Jane.
Yeah, I'm on the web meeting.
Okay, thank you, sir.
Very good. We'll roll in to adopt this morning's agenda. Entertain a motion.
Motion to approve.
Second.
Okay. Motion in a second. Further discussion? All those in favor, say aye.
Aye.
Those opposed, like sign. Agenda is adopted. We will move into the July 2021 minutes. I noticed a revision. I think it would be a revision. At the top, it has a telephonic meeting, but we met in person. Does that matter?
We'll make that notation, and we'll just take away the telephonic. Thank you.
Any other revisions? I'll entertain a motion.
Move to approve.
Second.
Okay, we have a motion and a second. Further discussion? Hearing none. All those in favor say aye.
Aye.
Those opposed, like sign. Okay, the minutes are approved. Now we'll move into the legal report, and I guess we'll jump into the rulemaking hearing, or do we want to do that?
It's not a hearing.
Okay.
We're just going to be voting on proposed rules.
Okay,
So if you want to do that now or after Erica, it's fine, whichever one.
let's go ahead and do it. Get
Okay.
it over with.
So based off of our conversations from the last board meeting in July, we talked about wanting to amend the rules specifically about continuing education to permit that to be completed via distance education. So in the rulemaking notice that you'll have before you, you'll see that we have amended two different provisions in the rules. The first one is going into the course guidelines, and it's going to take out the 50% language. And then the second provision is going to remove no more than 1/2. So I know that this was a set of rules that I said I would have drafted for us to the meeting, but last time I believe we were still having conversations about whether we were moving forward or not. Conversate.
Very good. I'll say this, at the Aero conference, the AQB said that they are going to make the synchronous permanent, meaning a virtual class. But they've had a great success with it, and they're going to make that permanent, where it was only temporarily during COVID. And I think originally it was to end December 31st. So that would fit into this also, correct? Because I think we, if I remember right, we adopted what they suggested through the end of this year.
Yes. So I guess my question would be to you is, are they adopting that as distance education or as live classroom?
But that's one thing I noticed in this is our terminology. Mm-hmm. And the terminology that is being thrown around is synchronous and asynchronous.
Correct.
And I don't know if we need to tweak our language to clarify.
I don't think so, because in the definition of distance education, it does mention a separation by time or location. So that is essentially a synchronous versus a synchronous course. So it would still fall under that category. So if they're continuing to use synchronous courses, then we can continue using that as well, but we would need to amend our rules so it would change the amount for distance education permission purposes. And right now, we currently have all qualifying education is permitted via distance education, so all that's left right now is going to be the continuing education.
Further discussion?
I'll make the motion that we accept as written.
Second.
Okay, we have a motion and a second. Further discussion?
A question. This expires the AQB in December. So what's going to happen between January 1st and when we get?
So I want to double check on what Commissioner Garrison said. I know that they're wanting to adopt synchronous courses permanently moving forward. I just need to know if we can do that to continue doing that until the rule is changed. So if that is the case, then there won't be a lag. But if we have to amend the rules, there'll be a couple of months there where individuals we'll only be able to do 50%.
I don't know when the 2022 AQB book will be out,
Okay.
but I know it's coming. Paria is in it, changes to it, so I know it's coming. And they showed us the red line version of all of it.
So I haven't seen anything from the AQB or ASC that was extending the education permission past the December 31st, 2021 deadline. So if that happens to change between now and our next meeting, which we would have likely have a rulemaking hearing, then that would still allow licensees to continue to take all of their continuing education courses online at this time.
Very good, thank you. We have a motion and a second on the floor. Further discussion? Hearing none, all those in favor say aye.
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 Those opposed, like sign. Very good. Motion passes. We'll move into the legal reports. And before we get started on that, several of these, I think we can block them together. I think we can block several of these together. And I usually look at them, write down the numbers of which ones we can block. Commissioner Atwood, did you happen to?
Well, I don't have their numbers.
Yeah.
The everyone that was recommended to dismiss, I think we can block all of those together and dismiss them all.
Okay,
Is that a motion?
that sounds wonderful.
Before I make that motion, and then others can chime in on this one. The ones that we that you recommended a letter of caution, I think we can block all those together as long as there was no civil penalty involved. I want to discuss the ones with civil penalties, but if it's just a letter, I think we can block those together. See if others. I can make that motion if you want me to.
Go ahead.
And then we'll have to go through and put all the numbers down, I guess. The motion would be to combine all of the complaints that have been recommended for dismissal for one vote, and also to combine all of the complaints that requiring a letter of caution, to combine those for one vote. That's my two separate motions, or put them all together. Yeah, two separate votes. If you want to, yeah.
That's two motions.
Two motions.
We're gathering the numbers so we can read that before you vote.
So could you answer a question? I didn't get a second yet, but anyway. Could you answer a question? The letter of caution does not go on their record. Is this correct?
That is correct. But Caleb, can you confirm that? Just, okay.
Yeah, I don't want any of these to go on their record. They just made a mistake. So
Right.
let's caution them, slap them on the wrist, say, don't do that again.
Right. It would be, and just for future reference, so a letter of caution does not, a letter of instruction does not, a letter of warning, and any kind of civil penalty does.
Thank you.
Very good. We have two motions on the floor.
I'll second both of them.
Okay. And before we vote, we'll get the numbers.
So I'll go ahead and read all of the complaint numbers that we are recommending to dismiss. 2021046 That's number 1. Number 2, 2021058 Number 3, 2021061 Number 9.
And just to point out, these are all the dismissals first, correct?
Right.
Okay.
Number 9, 2021059 Number 10, 2021061 Number 11, 2021062 Number 12, 2021064 Number 14, 2021067 and number 20, 2021067 And that's all of the dismissals.
Okay. Very good. We'll do the first motion on the dismissals. Further discussion on those. We have a motion and a second. Hearing none, all those in favor say aye.
Aye.
Those opposed, like sign. Okay, the motion passes. Okay, now we'll look at the letter of caution.
Okay. And the first one is number 4, 2021062 Number 5, 2021062 Number 6, 2021062 Number 7, 2021065 Number 8, 2021062 Number 17, 2021067 Number 18, 2021068 And those all have a recommendation of a letter of caution.
Okay. We have a motion and a second to accept council recommendation. Further discussion. All those in favor say aye.
Aye.
Those opposed, like sign. Motion passes. So what does that leave us?
Okay. I don't
Only
have
leaves
a
us 3.
Do you know which ones those are?
13, 15, and 16.
And I'll go ahead and just read those numbers real quick before we discuss,
Okay.
if that's okay. So 13, 15, 16. Okay. So 13 is 2021067 15 is 2021067 and 16, 2021067 And so the recommendation for all of those, well, and they're all in the same category. They're administrative complaints open because the licensee did not complete their CE requirements for renewal before the complaint was filed, obviously, and then they also have not completed it as of now, which separates them from some of the other ones on this report that we weren't recommending that civil penalty. So the recommendation was a $250 civil penalty and require them to meet their CE requirements within 30 days. And they would have to sign a consent order for that.
So are we looking at all these together or separately?
Whatever. I mean, they're all the same fact pattern. So it's up to you if you want to just ask general questions. I know that.
I have a general question. So we send them a renewed license, and then we're going to knock them $250 in. We have, several of us up here have had conversations about the ease of use potentially of the website and the information that is sent out to appraisers and or AMCs. And I'll be honest with you, it's not the easiest thing to navigate. So I feel like we're penalizing these people for something that probably looks like at face value is pretty confusing.
And there's also too, during COVID and the changes, there's been a lot of moving parts with CE, and it's confusing for me. And I'm sitting up here listening to it, at every something to consider.
Can I make a small comment on this? These were all people, I believe, that were granted an extension via executive order from the governor last year. So it's not anything to do with the website. We were giving them an extension based on the governor's recommendation. So that's the situation.
Stratwood, your microphone didn't activate there.
Thank you. I think number 16 is worded differently. Maybe I'm wrong. It says this administrative complaint based open due to respondent's failure to complete education. Respondent states, maybe they did, maybe they didn't. It just says they stated that they were confused because they did do their CE and uploaded these certificates.
So you're right.
They thought they did it. I just renewed mine 2 weeks ago, and I got confused. I think this one's different from the other two.
You're right, and I should have separated that one out in my recommendation. I haven't heard back from them, so I don't know if what they're saying is true or not. So I recommended, if I cannot confirm that they have finished, I'm not worried about the upload. I just asked them to send it to me. And if I can verify that they met the requirements, then close it with a letter of caution, like the other people that have become compliant after the complaint was opened. And if not, then we issue a civil penalty.
Last year, I would have been one of these. 2 years ago, I would have been one of these because I sent mine in, but it didn't go through. Because I didn't hit the final button that I was supposed to hit because I didn't know I was supposed to. So there is a confusion on that. So this particular one, I think we could reduce it to a letter of caution or something. No civil penalty. Now the other two, you can still discuss. I hadn't made a motion yet. I'm just discussing that with you.
Is that pending proof of completion?
Yes.
Okay.
Oh yeah, they have to. Yeah, sure.
Let's pull that one out and deal with the other two.
Motion to.
Well, let's clarify then again what they did wrong. They thought something and it was incorrect.
So for 13 and 15, the licensees have just explained that they thought that because they got their license renewed, that they didn't need to finish it. But they both said that they would finish it, just let me know what I need to do. So kind of waiting on us to inform them. And I wasn't real keen on a civil penalty either, but I know the program feels really strongly about it. So if they want to.
Talking about number 6.
I think we're talking about 13 and 15.
13 and 15.
The ones that are not necessarily confused and haven't been compliant. But, they say that they're confused because they got their license renewed, which I can understand that.
So civil penalty and consent order, that's going to go on their record.
And it goes to the national, I'm not familiar with it because I'm just helping out, but the AS.
Yeah, the registry.
Yes, the national registry. So
I'm just not willing, personally, for that to happen. I would like to see all three of these just get a letter of caution and verify completion.
Is that a motion?
I can make it a motion. All three of these. Go ahead.
Well, we do give all the appraisers that are registered in Tennessee the same notice, and it seems like only 4 of them can't figure this out. So, there's quite significant difference between everyone else being able to do it and these 4 individuals. So our position is that they were given ample notice, and a couple of times. They either waited to the last minute or claimed confusion, but I recognize there can be some confusion the first time or two. but I don't see how that could be a continuing theme. So that's where we stand on that. We think that we would be in line with the recommendations of legal based on that.
And I would just like to add this. If, as an appraisal management company, if I see them pop up on the National Registry for discipline, I have clients who will no longer use these appraisers. They don't care what it was. And we're talking about somebody who maybe was confused, maybe they weren't, but it's a minor item, I feel like, as opposed to someone who had 14 USPAP violations, wrote a misleading report. They get treated the same. So I think that's punitive in a nature that's not warranted.
Second, my motion.
I second Jim's motion.
I can appreciate. We hear the second. I can appreciate that, but I would like to remind you that your duty and responsibility is to the public, not the protection of your peers and industry. So I'd like to just put that out there.
So, are you the spokesman for the group? That's are all of you guys on the same page wanting this to happen?
We'll take the recommendation of the board.
Well, I know. What I'm saying is, do you have firsthand, did anybody talk directly with one of these individuals and they directly defied you?
Ms. Caleb, would you speak to that?
No, sir, that's not correct. But we sent out 3 emails to each one of these people that we gave extensions to. And of those 3 emails to each person, we received 1 response from 1 person 1 time.
Okay.
And it was giving explanations like, hey, you still need to do your CE. This was given an extension. Well, this was all done last year about the summer towards the beginning of fall. So it's been a while.
Technically, their license is expired then, correct?
No, we were, per executive order, we were
Okay.
giving a recommendation to be more lax on continuing education at the time. So we told them, hey, we're going to give you an extension on these hours. We go ahead and renew your license, but they will be due at some point. And we give them each one had a different date depending on the executive order.
And I'll just chime in. I don't think we have a spokesperson to necessarily. We just have a point of view.
Thank you. I didn't mean to offend.
No. We're not offended. I just wanted you to know that we ultimately will yield to the decision of what the board has made. We're just providing the additional context that may have not been provided in the summaries that you have before you. So I know that we have discussions about what information goes on the National Registry and what information does not go on the National Registry, and changing those names and different types of nomenclature in those. But I think one of the reasons that the program feels strongly is because they have provided notice. I know for a fact that if there are issues for renewal or any of those matters, reminders are given. And also, if there is confusion amongst the individuals, they can also reach out to the commission and ask those questions. So I understand that there may be issues that, we work on long term. So I just want to keep those pieces in your mind while you're making the decision. But ultimately, if you feel that way, that is perfectly fine and appropriate.
I'm going to throw hopefully a compromise on this. Do a letter of caution, and in that letter of caution, they have 30 days to comply. Otherwise, the penalty will and pretty much jar them enough that they either comply or they get hit with it.
If they don't comply within 30 days,
30 days, right.
You have to come back next meeting with another complaint?
That's when the penalty.
I'll send out the consent order if they don't comply within 30 days, and then they can either sign it and pay the fine, or they have to have a formal hearing.
That would be fine. And I would like to go on record just to say thank you, all of you, for working so hard and doing your job correctly. We don't want to get in your way, and we don't want to deter your enthusiasm and your work in any way, shape, form, or fashion. So thank you for your diligence.
Of course, and I appreciate that. I'm sure that my colleagues do as well. So if there is like an issue that we were stating before that is confusing, we can talk about that at another time during the meeting, during discussion otherwise. But we're wanting to make sure that things are clear for individuals when they get them. And these extensions, they agreed to them when they signed them. So that's just more information. But that's it. That's all.
Can I make a quick comment? We don't want to set this as a precedent that we are relaxing the standards, but because there was confusion, right? So if the language can include, and we need to remove the confusion in future by making it more clear in the notices, or so that's just my quick comment. Thank you.
Thank you. We have a motion and a second on the floor.
We have to vote that down.
Yes.
Do what now?
We have to vote.
Can't you just
We could amend
my motion? I can amend it.
We vote on the amendment and then we vote on the new motion, I think is how this would go.
However you want to proceed.
We can do it either way. Either way gets us there.
The easiest.
Let's go ahead and vote.
But on my motion.
On your motion.
Which excludes the 30-day.
Right.
All right.
Okay. We have a motion and a second. The motion is to waive the $250 fee, and they would receive a letter of caution. All those in favor say aye. Those opposed, like sign.
Aye.
Aye.
Aye, whatever.
Yep. Okay. So motion denied. It did not pass. So now we have a clean slate.
I make a motion that we, on these, all three of them, that we issue a letter of caution to include a 30-day requirement to show proof of education. Otherwise, we're going to go with this recommendation.
We have a motion and a second. Further discussion. Hearing none. All those in favor say aye.
Aye.
Those opposed, like sign. Motion passes. Very good. Thank you.
Thank you. That concludes the legal report.
Very good. Thank you.
We flew through that. Let's see here. Okay, experience interviews.
Had several of those.
I believe, Garrison, you're at the top of the list.
Yes, I'm at the top. I recommend approval for all of them. On what we received, Matt Gibson, I interviewed him the second time the end of last week, and I will recommend his approval. So all 7 of mine.
Are you?
Yeah, and we have one that we overlapped between Commissioner Atwood and myself. I'll let him do that one. So I'll say 6, all 6 of mine, and that's Anthony.
You're taking Anthony off of yours. Okay.
Okay. And Mr. Atwood?
Yes, all of those are recommended that are
Okay.
listed.
Okay. Commissioner Mansfield?
Yes to all of mine. I also interviewed Timothy Lindsay this morning, he's not on here.
Okay. Your mic didn't cut out, but you said you're going to recommend Mr. Lindsay.
Correct. I interviewed him this morning.
Okay. Would you all like to accept this as a whole?
As a group, yes.
Okay.
Yeah. I'll entertain a motion.
Second.
Okay. Okay, the motion is to accept all the recommendations. We have a second. All those in favor say aye.
Aye.
Those opposed, like sign. Very good. Experience. And now that we've got through that, it brings up a couple issues that I saw that I've experienced, and I'm curious if other commissioners have run into this. One has to do, and I always ask where they got their education. And I am seeing consistency with one or two providers, a weakness in reports. And so I ask them as far as what they're receiving during those education offerings. One in particular, they say, well, the instructor just reads the material to them. And there's probably not a whole lot of instruction going on. And I guess, and I battled bringing this up in the education side, but I'm curious, as a commission, what do we have available to hold an education provider to a certain level?
Ultimately, you're the body that approves those courses.
Well, they've already been approved, so they're out there in the marketplace.
Right, correct.
But we have no way to review. Is there complaints that can be filed similar to other situations?
For like course instructors or courses, so they're not necessarily licensed with the department, so we can't give them like letters of caution or anything of those matters. But courses do have a set expiration date, so if there is a course or a particular location that we're not happy or satisfied with, that is something we can certainly look into. Also, I understand like what the grievance is generally. Some of my other programs look at different metrics like pass, fail, those types of things when approving those. So if we wanted to look at some of those to be included in the future, we can do that. But for me, I really just see it more as not approving that course.
Okay.
I have a question on that. We're approving the content of the course, not the way the course is actually given. So how would we not approve a course based on the way someone's actually teaching it? To Rex's point, I've put multiple employees through some education in the last year, and they all come back with the same thing. There's a whole lot of stories being told, but not a whole lot of education going on.
Right. So they're stating that the content that they provide us with is what is being taught to students. And if that's not what's being taught to students, I still think that can be yanked backward. But
Yeah, and I've thought about this for some time. One, we don't have any type of review where we send someone out, sit through the class, and rate them. One thought I've had is especially as trainees go to file for their license, have them submit a survey of the education and maybe try to get some feedback from them as they go through it. And then that gives us a form of a way to measure the quality level of education that they're getting. And then that way we can look at that data, and as they come up for renewal, sort of question the renewal for the provider.
So if we're going to require students to do a survey or something similar to that, I think that might probably have to be a rule change that we incorporate. But as you were stating below, I don't see anything in the rules or statutes that would prevent, for example, Professor Jane sitting in on a course. And if if Dr. Jane is looking at a course and it's not whatever, so he could provide a report back to the commission. And I know that that does occur in certain places. So if we're having those issues with certain individuals, maybe that is something you might want to look into doing.
I've thought about sitting in one, but I know I'd probably be called out. They would know me, but that's okay. That may help them step up their game. I don't know. And I think other commissioners would be that way too, just recognizing the name more so than the face. But that may be something we ought to do.
Yeah, if I may make some comments here, I think this is a fairly important topic in terms of quality management. And we've been getting a high volume of courses, but we are doing the commission staff and the education committee, we are doing quite an in-depth review of the content of the materials. Not delivery we can, but the content. And even this time we had 4 where the content was not supplied to the satisfaction, so we are not approving it. I like the idea of sitting in for problem. I don't think we can sit in for each one before approving. The volume is just too high. But if we can identify problem providers, definitely I think making a visit to the course is a very good idea to ensure that the quality of education received by the licensees is of the highest quality. Thank you.
When I teach in Alabama, the state has not every time. It's not an every time situation, but you never know when they're going to show up. They have somebody from the state show up, and they're reviewing the instructor, not the content. They're reviewing whether the instructor actually teaches the content or not. They monitor the time so that you don't quit early. And I'm getting a lot of comments that certain instructors are not staying the entire time. They're letting them out quite early. Then when I begin to ask questions to the trainees about basic appraisal principles, and they don't know the answer, I said, well, weren't you taught this? And their answer almost always is, I don't remember if we were. They probably were taught it, and it may have been their fault for not learning it. I can understand that. But there's a consistency in who these providers are. And, since I'm an instructor for one of the providers approved by the state, I have to watch what I say that I don't sound prejudiced in some direction. But at the same time, I don't think we're providing the education for many of these trainees that needs to be provided. They can't answer the questions a lot of times.
So the rules state, that 50 minutes of teaching is considered an hour. So if individuals are not getting a certain amount of education, or not looking at like teaching methods is a little bit trickier because it seems kind of subjective, the person to person. But course hours, that's very objective and something that we can look at as a yes or a no. Or also looking at what is supposed to be covered in the class that's submitted to us versus what's coming out. So if that is happening, I think that would just be information that I would bring back to the program, back to Michael and Caleb, and then we can decide like next steps from that point. So I know that it's a little bit different because it's courses and not, well, you also have to approve course providers, right? Okay. So if you're providing courses and course providers, that approval is dependent upon your decision making. And so if that is something that you want to consider looking at, we can look at different.
At
So
this
that
point, it's all
go ahead.
hearsay.
Yeah.
You know, he said, she said,
Right.
so we don't have any proof of anything.
Right. So that would be, at that point, you know, someone going to the class and appearing, not announcing it because that's not going to help, but going in and listening. But I don't think also if we had like a complaint submitted from a student, I don't see that as hearsay. I see that as they're there in the particular course. And if they want to submit that information to us, we can look at it.
Sad part is they don't know what they don't know.
Right.
As far as a student. And a recent one of mine, I felt sorry for him because, and I point blank told him they did not prepare you, and you paid them money and they did not prepare you. And I guess in seeing some of the trainees and the level in which they're coming out of this education, since we are the governing body, we need to hold these providers to a certain level. And do the providers renew periodically? Okay. Of course. Okay.
Caleb, your microphone was up, but what Caleb said was that we don't approve providers, but we do approve the courses.
What about the instructors individually?
Nope.
I'm only looking at approvals for instructors when it's AQB course. When it's when it's a USPAP course.
Okay.
That's how I approve it. Yeah.
So based on the conversation, I think we have, you guys are talking about specific places and people. So if we want to discuss that further, I would check with Michael, Caleb, and Tony before we would do that. But I don't think just because you've approved someone and they're not following the requirements that are provided and required by the AQB that they, once it's approved, they have like carte blanche to do whatever they want.
So I have another cog to throw in the wheel since we're on the subject, and that is the supervisors are also not doing their job in the trainees that I'm interviewing. I'm almost, I can remember when I first became a commissioner, we had a 15-minute conversation out there in the hallway at 4 times, an hour before a commission meeting. We come in and approve 4 people after a 15-minute interview. My interviews are over 2 hours now. And in many cases, they are, they don't pass on the spot. They have to do additional work because the work that they provided is not sufficient. And upon asking certain questions of basic appraisal principles, they don't know the answers. And so I have to require that they go back and do another appraisal or rework this one or something like that. And many times the supervisors are teaching them inappropriate and incorrect techniques. So when you ask them, well, how did you get this adjustment? They come up with some off the wall trick that their supervisor learned 20 years ago and has used it for 20 years and gotten away with it, and has absolutely nothing to do with proper appraisal procedure. So it's not only education, and you know, if I feel like I end up having to educate them, and I don't. It's not necessarily my job, I don't think, but I can't approve them until they understand the basics, and they don't know them in many cases. Maybe somebody else has that problem. Maybe it's just me. Maybe you're only sending those to me.
Yeah, no, I that's consistent with what I'm seeing too. Not all of them, but they're, and I've started to take note where they're getting their education. The other thing on the supervisory is if they're related to their supervisor, the instruction is weaker. I've run across that in this last batch. But I guess on the education, and on the supervisory, I think Perea will help with that some. You know, there's a change on the horizon for it. Education at this stage, maybe we test the waters. Maybe we sign up for a class. I'll go sign up for a class and experience it and see if it's consistent with what I'm hearing from the trainees, and we can discuss it in January or February or April, whenever, you know, the next couple meetings, when I can work one in.
I think what we'll want to do is probably come back to you in January once we think of a list of ideas, because we want to make sure that everybody's kind of doing the same thing.
Oh, that's good. Yeah.
So we can consult with Michael, Caleb. I can consult with everyone to figure out that is a process that you want to move forward. So let's put that on pause.
I don't have time to take one between now and probably February anyway.
Right.
So that's good.
But also, I guess my question kind of would be to the board at that point. It's my understanding that if you're a supervisor for a trainee, that ultimately you're the individual that is responsible for their work.
And that brings up another issue, and this falls on the supervisory. And something that I battled, I had 2 trainees. All 3 reports were short-term rentals, meaning they were vacation cabins, and they were doing them on a URAR with no income approach.
A UA.
URAR, it's a residential form.
Okay.
And for a single family house. And I wrestled with the first one. I actually went through the interview and I talked him through everything that was wrong. And it wasn't the trainee, it was a supervisor that gave him that property. This is the way we do it, and moving forward. In both situations, I could have turned the supervisor in. But if we get during the trainee process, if we're turning in supervisors, the trainee well will dry up. And that was another issue that I've had. We need to put out some kind of public service announcement cautioning residential appraisers in doing short-term rentals. Because one, if they're certified residential and the client, the lender is sending them a request, the client wants the residential appraiser to do it because it's cheaper. But the burden falls on the appraiser in accepting the assignment and accepting and acknowledging that they have the competency to do that property.
Not even the competency, but really the licensing. I would argue that a residential appraiser isn't licensed to value a short-term rental property, even though that looks like a residential property. They're taking these, and you talk about protecting the public. I mean, they're taking these and putting them on a Fannie Mae secondary market secured form where they're only securing the interest of the real estate, when in reality there's a lot more going on in these transactions than just the real estate. And so it's a new kind of emerging property type and a new issue for appraisers, and there's not a lot of information. I think anybody who's doing it's because they don't know what they don't know. And so I think putting out some FAQs, at least on the website, we definitely need to do that.
If I may, it sounds like we're getting further away from the germaneness to the education report that we should maybe focus on. It sounds like if this is going to be a conversation, we can pick it up in new business.
That'll be great.
Okay.
Let's shift that to new business and get back to the education.
Yes, so this is Professor Jain. The education committee and the commission staff have reviewed, like I said, a very high volume of requested course approvals this time, and a number of them had not provided full content. That's what we are requesting from the providers now to ensure quality management. So those are not included because they were not immediately approved. We have requested for additional content. The ones on the education report are deemed to be of high quality according to our analysis, and we recommend or make a motion that these courses be approved after. But we had good discussion also of any additional steps we want to take to further ensure that the quality of education and experiences are good. None of these reports, by the way, relate to the experience. They're all CEs, or continuing education. But I would like to make a motion to approve the ones which are reviewed favorably.
Very good. We have a motion. Is there a second?
I'll second.
Very good. Motion and a second to accept the education. Further discussion? All those in favor say aye.
Aye.
Aye. Those opposed, like sign. Education is approved. Thank you, Commissioner Jain.
Thank you.
Turn it over to the director.
Okay. Sometimes I forget to hit the speak button too. So in your packet, you received the year-end statement or NPS report from our fiscal team that was for the month of July. That shows you how the fiscal year ended. And the other NPS statement that you received was for this year, current year, well, as current as I have through September. So at this time, I just would like to see if there are any questions regarding any aspects of the NPS reports.
I have a question on the year-end reserve balance that looks like it's projected to be a little over $3 million by the end of next year. Is there anything in place where we have, obviously we've talked a little bit about proctoring potentially classes, but decreasing fees, anything like that, as that surplus continues to grow and grow and grow and grow and grow, or what is being done potentially with those funds at all?
The discussion on decreasing fees has not occurred since I have been on staff here. So my understanding of that process would be that you all would take it up and make the recommendation, at which point we could then put that in place. There have not been any discussions with how to use reserve funds. By statute, we're required to show 2.5 years of operational budget, which we cover here. So at 2.5 years, it's a little more than gosh, it's more than half. So there's not, when you factor in the operational costs, and I can drill into it a little bit more and get precise numbers, but when you factor in operational budgets over the last couple of years, coming in just right around $600,000, you're looking at 1.8 million. So maybe a little over half is operational. So there's about another 1.5-ish. I'm just ballparking here. These aren't exact numbers. Many of you are far better at math than I am and should be, doing this on the fly. If you all wanted to have that discussion, to talk about, things that you would like for us to look at, I think we'd have to look at sustainability for one thing, and would it deplete reserve funding past what we're required to have, or would it, is there a way to keep funding coming in at the same levels, but also have some sort of a program that you're talking about?
I think in the past, one idea was throwing out providing all the licensees a copy of the most current USPAT. And some states already provide that. But that was a thought probably 2 years ago or so when the same topic came up as far as how much money we had. Pretty much just trying to give back to the licensees, but in a constructive way.
I think there are other programs that do similar, take similar actions. So this wouldn't be a first for any of our, or for a number of boards in this division. So that's something we would need to put some thought in and some structure to. We would also have to have our fiscal team take a look at and crunch the numbers to make sure that, where the appropriate balance is between fee deductions or fee reductions and, maintaining the appropriate levels that we need to have on. But yeah, we can add that conversation to a new business discussion, or we can bring it up at a meeting when you're a little bit more prepared.
But why don't we bring it up at another meeting, and y'all can sort of think about it and brainstorm and also see if it's, if we're on the right track now, or if we need to adjust it.
A quick comment is insurance risk has the jump risk. So when the costs come, I think can be very sudden. So it's good to have a good reserve. But at the same time, the idea you mentioned is a very good one to reduce risks upfront, right? By, for example, distributing the USPAP materials so everybody is in compliance. Thank you. Yeah.
Thank you.
Approve this.
To start preliminary discussion. That out, and then we can decide from there where to go.
But no, to answer your question, no, this does not require approval.
Okay.
This is informational. Let's see. The next thing I would like to ask Mr. Garrison if he had, being the resident appraiser on the scene, if he would like to give a summary of the Aero conference.
Okay. The Aero conference, I've got some highlights from the AQB. One thing they know, and I think we are already doing this based on the questions that I asked a trainee, but they are going to require that the experience be completed prior to the exam. In the past few trainees, I've asked them if they've taken the exam, and they say no. But that is one thing. I think one state sort of got in trouble with this process, but they want the experience completed prior to the trainee taking the exam. The other note that I had, we discussed, it concerned the synchronous. The Appraisal Standards Board. One thing to let you all know, the new standards, USPAP, will not come out until 2023. So it'll this 7-hour USPAP update will not cover any changes because there are none. It hasn't changed. So the next 2 cycles are going to be tricky. They have put out a new 7-hour USPAP that will consist of an hour of top complaints that states receive. And the majority of the 7 hours is going to be how to use the USPAP book. Yeah. So, but I wanted to let you know, and personally, I've thought, well, my cycle's not up until next fall. Do I really want to take this 7-hour USPAP and wait? But I'm afraid they won't have the new class out until late next year. But so as you see CE come in, you may very well see that some appraisers took the, 2020, 2021 USPAP twice. And that probably should count, even though it's a repeat, because that would probably be more beneficial than the new one. But so I wanted to make you all aware. So now USPAP, when it comes out in 2023, will probably be at an odd year for everyone's cycle, 2-year cycle, because it'll then be 2023, 2024 for the new USPAP book. And they went over several changes that are being proposed, but it's early since they're not going to approve the 2023 until later next year.
Does that mean from here to 2023, we're only going to have the 2021 version of the use course?
Yes.
Okay.
Yeah. Well, we're still playing by the same rules we have been in the past 2 years.
Okay.
Yeah. The ASC mentioned several times they have grants available for states to look at programs to bring new people into the business. That's something somebody has a great idea we can look at. There's South Dakota has a program right now that they've received a grant, and it is a process to get trainees through the experience side outside of the new Perea. So that's something to be on the lookout. In a board breakout session, one thing that was discussed a lot was board training. They asked the question, do the board members receive training? And some of the items on the training is how do the meetings flow, ins and outs of the board, how to handle cases, different things like that. As new members come on, providing some board education. The other breakout, it was the modernization of appraising. There's a push by one large AMC out of California. They presented an infomercial pretty much on what they're proposing is a property inspector to go out, look at the property, provide a report to the appraiser, and the appraiser sits at his desk and does an appraisal. But they have some technology on how to measure a house. Well, it's not how, it actually does it for you. And they were presenting that. Probably the biggest topic is the PREA and the changes that are on the horizon that would be in 2022 AQB book will be the non-traditional appraisals. 100% will be allowed for experience, not just 50%. And also some states, and I know we have PREA on old business, but I'll go ahead and talk about it here and we can get it over with. The Appraisal Institute was given a $500,000 grant by the Appraisal Foundation to come up with a PREA program. Apparently there are about 1,500 people on a waiting list to do PREA across the country. Several states have approved PREA. However, Michael and I talked, I guess we shouldn't be like Congress and pass something that we don't know what it is before we pass it. So let them sort of present what PREA will look like before we go down that path. You know, they threw out a question asking states if you approved it, would you approve it without seeing it? And I think it would be prudent to know what it's going to consist of before we handle it as a board. And I believe that's it. Questions?
Anyone have any questions about the Aero conference? Okay. It was a nice, quiet weekend in downtown DC. Everyone had gone home, so it was easy to get around the conference site. But as for additional detail, I don't have any to add. I think Rex summed it up pretty well.
I do have one question, and you may not be able to answer it. So, in 2022, I need to take a 7-hour USPAP course that I've already taken. And then in 2023, I got to take another one. So I'm going to take one every year rather than every 2 years.
Well, the next one is not the normal USPAP.
The next one, which?
The one that just came out, the brand new one, it's going to be mainly how to use the book.
Do I have to take that one?
I don't know. It depends on your cycle. If you just renewed.
I just renewed.
This would be my recommendation. I'd wait until next year and take the 2023.
Will the 2023 only be good for 1 year? And then
no, because the 2023, it's my understanding that the new USPAP, in the past, they've been even numbers or 20, it would end in an even number. I think that's right. No, it ended in an odd. It was 2021. Yeah. So now it'll be ending in an even. It'll be 2023, 2024. Well, and it's really going to throw the 7-hour USPAP. Everybody's going to be off because they have, at least I'm this way, I have the same time of the year that I hit USPAP. And where it's going to impact, some states you're required to take USPAP within 6 months of the new book. And so they're going to be caught in the same quandary. Do I take this one or do I wait?
See, I have an advertisement for the new USPAP class, but they're calling it a USPAP update for 22-23.
That's not what they presented, because actually the 2022 and 2023 USPAP has not been approved. They're still going through
They reference
exposure.
using the 2021 USPAP book,
Yeah.
but they're advertising it as the USPAP for 22-23. And if they're coming out with a new USPAP in 23,
Technically, you could take that USPAP, meet it for that cycle, and not have to take the next one until your next cycle, which you wouldn't even be privy to any changes that are in there. It's.
I will say that I've only seen 2021, and we have had 2 or 3 22-23s come through already in the state of Tennessee. So that is what is coming through as.
And it has, from my understanding, very well, there are no changes to the standards, so it's just covering how to use the book.
Hi, Michael. This is William. I have something to add.
Yeah, go ahead.
For the USPAP, our rules do not specify any particular year of USPAP update, so it's actually, even pre-COVID, been extremely common for appraisers to repeat courses. As long as the USPAP update course was completed during the licensing period for that renewal, then we can go ahead and accept it. And so it's really up to the appraiser to determine which particular approved USPAP course update that they want to take. So for licensing purposes, it really has no impact on which one they take, as long as it's approved. And as Caleb said, currently we have 2021 USPAPs approved, and we actually have a 2022 to 2023 USPAP course that's approved, and we update the approved course list as the courses come in.
Very good. That's good information.
Mr. Atwood, you can accept Mr. Garrison's recommendation at your own risk. Are there any other questions regarding the conference? If not, I have some meeting dates for next year that I'd like to propose. But I'd like to first start by saying I'd like to shift these meetings away from first thing Monday morning. Given the technology and things that go into it now, if there are issues, Monday morning at 9 a.m. doesn't give us a lot of reaction time. It also, if anything should go wrong with anyone's attendance over the weekend, we are required to have a physical quorum for every meeting now. Physical in this room, online doesn't count. So with that in mind, I'd like to propose moving these to Tuesdays. We can keep 9 a.m. if that's all right. I've got a number of dates here to throw out to see if you guys are okay with them. Okay. I've selected 2 Tuesdays for each meeting where we would keep the same months that we currently meet under, which is January, April, July, and November. January 11th or 18th. If there's anything that you currently know of that would prohibit you from meeting on that day, let me know. If you prefer one day over the other, you can throw that out there too, but this should be a discussion just to make sure that we get everybody on the same page.
I have a court date on the 11th.
18th? So it's not a prolonged legal absence. All right.
I hope so.
Okay, we'll mark January 18th, April 5th, and April 12th. So these are, I'm focusing on the first 2 available Tuesdays of each month.
Wilson.
12 and 19 or 5?
April 5, April
Okay.
12.
Yeah.
Okay, let's knock out April 5th. Same dates for July 5, July 12. The 4th of July is the Monday.
I want to do a Monday situation for you.
Are we off on the Tuesday?
Do the 12th?
12? Okay. July 12. And then last is November 8 or November 15th.
Say November.
Okay. Well, I wouldn't want to prohibit anyone from being able to stand in line at the polls of their home precinct, so let's go with the 15th. And I'll send these dates out. What we'll do now is we'll get them posted to the website and send out an email reminder.
So can you please quickly repeat the 4 which you selected?
Yes, sir. That's January 18th of 2022, April 5th, July 12th, and November 15th.
Thank you.
And those will all be Tuesday mornings, 9 a.m.
Very good. Thank you.
Now, did you say that we had already covered the Perea discussion
Yeah,
to your liking?
we've covered it. Are there any questions concerning Perea?
We're continuing to put that off until they come up with specifics.
Yes.
I'll keep it on the agenda so that we don't lose sight of it. That way, if anything comes up that you all hear of in between meetings, it'll be there to jog your memory when it comes back around.
As of right now, there's not a provider out there for it, so we won't see anything come through the office as far as for approval. Very good. We'll move on to the second old business, independent appraiser reviews. Anna, were you able to find anything definitive?
It's split across jurisdictions. So I did do some research, and of the research, I found more jurisdictions stated that they would prefer an individual to be licensed to do those reviews, but we also have states that do not have that requirement. And we also have states that just don't talk about the requirement. So I think at that point, I think a discussion is still a really good decision to have regarding these. The board is permitted to interpret its rules and statutes as they're written, but I think it would probably be a good idea for us to get sort of on the same page, or make way to making like a uniform decision. Because right now it looks like, from what I'm seeing, it states that people are interpreting for Tennessee that you need to have Tennessee licensure. So any further comment, I think that I can defend really kind of either way. It's a gray area, which I'm sure you guys have looked at before, but some people see it as very much black and white. So it just depends upon the will and decision of the board.
I think it would be good to have some clarity to it, and it would probably make your all's job easier too, if you field a question concerning it, you could answer yes or no.
Yeah, from a use PAP perspective, it's about scope of work. So if a review includes agreeing with, disagreeing with, or coming up with the reviewer's own value opinion, then that's an appraisal. And in my opinion, they ought to have a license to do an appraisal in the state of Tennessee. But if the review scope of work does not require that, it requires USPAP compliance, quality of another appraiser's work based upon general knowledge of procedures and principles of appraising, then an appraiser really anywhere would be competent if they claim competence to do that. They wouldn't have to have a license, in my opinion, to do that. Now that's just the way I would look at it. But now, if it does include doing an opinion of value, they would need a license or certification for that.
We get a little more specific. This is going to be affect me a whole bunch by the sounds of things. Yeah. Specifically, we send a lot of reports back during our compliance process to appraisers that say your value is not supported. So I'm disagreeing with the value at that point. But I don't have an appraiser doing that. But if their value range is outside the range or it just doesn't make any sense, then I'm sending it back. So are we saying that I would have to have an appraiser say that?
Yeah, and what you're bringing up was in a breakout session at Arrow. You're talking about your compliance, right. An AMC compliance.
Yes.
The discussion we're talking about, and they sort of...
They overlap.
They overlap.
Yeah.
What we're talking about is any review. And with regard to your topic, the person that presented, they basically said, if you could clear it up for us, it would be helpful to know if it needs to be done by that particular state reviewer or not. Right. And I'm sure you run into it in several states. It's not clear, so you end up erring on the side of caution.
I have one of our appraisers who's licensed in 7 states.
Right.
For
being
able to say your value is not supported.
Yeah. And I think from that side, and I forgot to do this. I wanted to look at the AMC law to see if we were clearer on the AMC law, because the AMC law is newer than the original, what came out in there.
Well, I know one of the things in there is that we are required to make sure a report is USPAP compliant before it goes out the door. And a lot of times, those things are falling over each other, value and USPAP compliance, because if it's not USPAP compliance, there's probably something wrong with an adjustment or a value, or 60% of the time it's put in your 3-year comment or something like that. But yeah.
So I think some clarity would be beneficial, both for the AMCs and for appraisers doing reviews. And the amount of reviews, you would probably agree, since, say, 2010, there's more reviews today or during that period of time than ever before, even when the license was originally adopted. And my concern, personally, is not right now when things are going well, but when it goes the other direction. I've got a feeling that because there's so many reviews, if a lender takes a property back, they're going to have an appraisal and they're going to have a review, and they may turn them in together. And so we'll receive a complaint, but if the reviewer is outside our jurisdiction, we can't go back on them.
Right.
And so I think it's just trying to clear it up before we move forward. And in looking at the interpretation, I come up with the same thing that Anna, that it is required to be licensed in Tennessee, but it's not communicated that way.
So when we specifically say, I know there's, some terminology that we're bounce back and forth, standard 3 review, or, but if at any point you say your value is unsupported, that drops it into a standard 3 review in your opinion?
Not necessarily.
Okay. Here's another thing that we run into, unfortunately, frequently. We will say the report is adequate, and we will send it on to the lender, and the lender will look at it, and if a report they're scored now by Fannie Mae and Freddie Mac. If it's under 2.5, they consider that a repped and warranted appraisal, meaning they will never come back on that appraisal for a repurchase demand to the lender. So those reports get virtually no screening. It doesn't mean the report's good. It just means it met an algorithm. And we've talked about this before. We've uploaded those at different times, and the score changes based on we don't know what. Same report with a comment change. Went from a 2.3 to a 4, or a 5 to a 2.1, with no other changes to the material of the report. But we are already starting to see Fannie Mae coming back on anything over a 2.5 with a page-long litany of you need these items addressed in this appraisal report, and you are really bouncing back and forth across the line based on some of the things that they're asking. And why didn't you use these 5 other comparables that they had in the neighborhood? So I need to be able to understand. I don't want to facilitate something that I know is incorrect. We have a hard enough time now telling people you can't do that. So I want to make sure I'm toeing the line here.
Well, preferably what you would say is the adjustment is not supported, not the value is not. If you, and that means they didn't put anything in there. They didn't show any paired sales. They didn't show any reason why that $50,000 condition adjustment. They just didn't do anything. That's not an opinion of value. That's a statement of fact. They didn't support that adjustment. So if it's a statement of fact, you don't have to be an appraiser. If you give an opinion, you have to have an appraiser.
And just on Jim's point, I would say we see less than 10% of all the reports that we look at on a compliance level that have any paired sales analysis in it. They just don't do it. And then you ask for it, and that's the craziest thing you've ever asked for. Sorry, Anna.
Oh, you're fine. I was just going to say, so Commissioner Garrison, after you said, let's look at the difference between the AMC law and the regular law and the non-AMC related, I looked at the definitions for appraisal, and the AMC law matches the previous law, except the current one that doesn't apply to the AMC. It says appraisal does not include any opinion of value referred to as an evaluation under 6239-104. And so those are some of our exemptions. And these are what the exemptions say. This chapter does not apply to any evaluation of the value of real estate serving as collateral for a loan made by a federally regulated financial institution, or to any evaluation of the value of the assets of a trust held by an institution, provided that the applicable federal regulator does not require an appraisal by a state licensed or state certified appraiser for that loan or trust, that the evaluation is used solely by the financial institutions in their records to document the collateral or asset value. The evaluation shall be labeled on its face. This is not an appraisal, and individuals performing these evaluations may be compensated for their services. So that's one of the exemptions. The other two exemptions state that it does not apply to a full-time employee in the ordinary course of business that gives an opinion of the value of real estate to the employee's employer, provided that the opinion may not be represented as an appraisal. It also does not apply to any person who is registered with the State Board of Equalization while performing any service of any nature for any taxpayer before any tax or assessment authority. And it also does not apply to a real estate broker or a salesperson licensed by the state who in the ordinary course of business gives an opinion to a potential seller or third party as the recommended listing price of real estate, or an opinion to a potential purchaser or third party as to the recommended purchase price of real estate. This opinion as to the listing price or the purchase price shall not be referred to as an appraisal, and no opinion shall be rendered as to the value of the real estate or real property. Those are the exemptions that are listed.
Right.
So
as an employer, my employee says the value is not supported.
The employer in that, it was always understood that if it was a financial institution, if they were an employee of a financial institution, that was the exemption.
That's what I always understood, but that's not what that said, was it?
Well, yeah, I heard the same thing. But if that's another gray area.
So really, any reconsideration request coming from a homeowner or agent through an appraisal management company is a disagreement of value, and here's sales to consider, correct?
Yes.
Yeah.
And this has been ramped up unbelievably over the last year. Now we have departments inside of lenders who will approve these things, and they are appraisers. I have one specific nationwide lender who will remain nameless because I want them to continue to be a client. That's an appraiser signs off on these things. So I mean, they're giving their opinion at that point, and sometimes get extremely specific in the
they're
process.
exempted because they're an employee of the financial institution
Without coming up with a number. Yeah. But I'm the one who's relaying the information.
What happens during the times we're in. So based on what you've read, do we put out clarity that you need to be licensed in Tennessee to do review work?
I think that is going to make us, or if we're going to provide, this is what the law says on this particular matter. If you think you fall into this category, you would need to be licensed. Otherwise, you would not need to be licensed. But ultimately, if it came to be a question of whether yes or no, that would be before you in a complaint purpose. So we can make an opinion. I don't think that opinion necessarily has to be binding by any terms. It would just be an interpretation of how we read the statute at this time. So if that's what you want to do, we can. But if we don't want to have a firm stance either way or another, that's another route we could go. So if this question came to us as a program and they would say, hey, this is yada, 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 what do I need a license? We don't give that information over because we don't give legal opinions. So I would provide them, this is what the rules and this is what the statutes say. You can make your own determination or consult with a private outside attorney to make that determination.
I like clarity. And it, I think it would be wise to clear it up and be more black and white with it, first, and not be in a gray issue.
I feel like if you do that though, we got to be very, very specific on what a review is.
Yep.
How we will look at reviews and interpret what that statute says. So, for example, we say that you need to be licensed in Tennessee. So if there's a complaint filed, hey, this person is unlicensed, and they give you the different facts and circumstances, it would come to you in a complaint form. So you would have two options at that point. The first one would be to apply the interpretation that we read. The other would also be to look and read at the facts and circumstances provided to you for that specific complaint to see if it applies or not. So if we were to say this, that yes, you need a license in Tennessee, that doesn't stop anyone from not necessarily doing that work in Tennessee. That is the preference of the board.
I guess my thoughts too, we could maybe handle this under an FAQ and give a few scenarios and give an answer to provide some clarity. And we come up with those scenarios and we give an answer, and that would communicate
But at the end of the day, we can come up with those guidance. I would still include like a disclaimer information saying this is very fact dependent. So if the fact and circumstances are different than what they are in the FAQ, which can be a change of, just a smidge, then we would look at it on that form. Right. So I don't think it excludes us from making, a decision like, oh, nope, they need a Tennessee license. It just gives us more clarity of what direction we will typically go into and kind of have a mindset. So this is what the board thinks. This is how we interpret your rules. And then at that point, it's like, do you want to test the board or not? If it were to be provided to them in a form of complaint.
Thoughts from other commissioners?
For me, it just boils down to competency. Is the individual doing the work competent to do the work? Did they explain their scope of work? Even if somebody's licensed in the state of Tennessee doing a review in Hohenwald, have they ever been to Hohenwald? Do they know anything about Hohenwald? Are they familiar with that market? They've done a review and they got a license in the state of Tennessee, but are they competent? So, for me, the only issue is competency of the individual and was their scope of work properly disclosed. That's it for me.
I'll just also, we were stating before the definition of what a review I can give you what the statute says. The definition of assignment is. It states means an analysis, opinion, or conclusion prepared by a real estate appraiser that forms an opinion as to the adequacy and appropriateness of a valuation appraisal or an analysis assignment. I don't know if that helps or makes it more confusing or does nothing.
I think where it gets confusing is when it shifts to the appraisal process. It focuses more on the appraisal and not necessarily the review. And I think when that was written in the early 90s, there wasn't that much review, and that just didn't get slid in there. But I think that's where the gray area comes in.
So, like I said before, ultimately, it's the decision of this board how you read your rules and you read your laws. If you read it one way, then that can be one way. The only reason that it would be more solidified is if there was a specific ruling from a court that said this is how we see it, how we do it.
How's this for an idea? Send out the excerpts of what you read to all of us. Everyone can think about it, read it, think about it, and we can bring it up at our next meeting. And that way we can maybe have better discussion. And, the thought process as commissioners leave today may think of something and may help the situation. So,
and in the interim, I'll do some research to see if we have any cases on point that directly state what for Tennessee how it's read or interpreted, and I'll bring those back to you. But when I was doing my research before, there's actually a document on the internet about the appraisal reviews, and it goes state by state of how they read it. And on that document, it was interesting to see who had an opinion, who didn't have opinion, and what it was. So it is, I don't think this is going to be an issue that is completely cleared unless there is like a very clear and specific statute or rule put in place.
I know Kentucky and West Virginia require you to hold a state license to do review work. And the reason I asked, I had someone, and this was several years ago, to review an appraisal in West Virginia, and I called their board to find out if needed a license, and they said yes, and that was quick. I can turn that assignment down.
Yeah, I will say like our neighboring jurisdictions around Tennessee do read the law that way, but there are jurisdictions that also read it the opposite way. So, and those would only be persuasive and not binding.
Yeah, I think most of the states around us.
Yeah, no. Yes.
And what makes it difficult, and I've heard this from some review appraisers, that in Tennessee, that a reviewer in Kentucky can do review work in Tennessee without a license, but if he does review work in Kentucky, he has to have a license. It's sort of not fair.
We do a straw poll, a non-official vote, and just go around and say, are you interested in pursuing this, or do you want to leave it the way it is?
Well, the way it is just sort of gray.
Well, you see, we're going to, in order to make it black and white, it's going to invest a whole lot of time and effort.
That's fine.
So I guess
be ready.
That's what I just say is, let's just have every commissioner say, are you willing to put that much time and effort in this, or is this not that important to you? I mean, I don't know. nobody else is really talking but me and you and Jason. So,
Well, I mean, from what it sounds like, no matter how much we try and get down to black and white, Anna, you're saying we're still going to have gray regardless.
If you read the way I read the rules and statutes, I don't see something that is like concretely says yes or no. I think if you're looking at scope, as you were saying before, that's not mentioned anywhere in the rules or laws. So is that a review? Is that an appraisal? So I think the more specific that we get regarding it is going to kind of dictate what we make a determination is. So like
but USPAP is the law here, and it is specific in USPAP what scope of work is, what the definition of a review is, what the definition of an appraisal is. Those are very specific in USPAP, and that's what we've always gone by, those items. And again, my view on all of this is it's just too much time and effort to try to do something when it's still going to be gray. And so we wait until a specific complaint comes up. We judge each complaint on its own merits.
Here's an example, and this came up several times a few years back. Retired banker in East Tennessee is no longer working for a lender, but he's doing appraisal reviews, is not licensed.
What's his definition of?
Well, here's the thing. He's not licensed, so he's not complying with USPAP.
Coming up with an opinion of
going back to his question.
If he goes back and he questions value, and this is where I was getting complaints from appraisers that they were getting questioned by this particular reviewer, and he wasn't even licensed.
So I'll flip that a little bit. Appraiser who's doing compliance reviews, but not signing them as an appraiser, is doing the same thing.
And
I'm just stating the fact that I know. I know several who work for community banks who are appraisers, and some of them practicing appraisers who also do compliance work, and they do not sign their compliance reviews as appraisers. Different hat.
But they're employees.
No, they are not. They're third parties. There are a lot of community banks in this state use appraisers to do their compliance review work. And they're also actively working appraisers.
And they're already.
But they're not signing the report as an appraiser. Back to the
then
evaluation.
I think that's an issue. Based on definitions that we heard.
You can wear a different hat? No? You can for an evaluation. Why can't you for a compliance review?
The different evaluation is specifically excluded.
I'm just trying to understand, like, would be appropriate to take off your appraiser hat and just declare yourself an evaluator that's not licensed, because once you're licensed, I think you're bound by the rules and statutes.
And that's why in our FAQs for evaluations, you can state your certification.
And we also had that conversation that if you do that with Jim, that's now an appraisal.
No, it's not.
We'll agree to disagree on that.
That's why our FAQs read.
And I think it's incorrect.
Well, that's the way the laws. You just
Yeah.
mentioned the exclusion. So
Your
if
son-
you're an appraiser and real estate agent and you're giving an opinion of a listing price, that doesn't constitute an appraisal based on Tennessee law, correct?
But
Same way for
if
evaluation.
is there anybody in here who's a real estate agent that when
Yes.
you sign your contracts, you put your appraiser license on there?
It's a different, it falls under a different jurisdiction.
You just read that you're excluded from.
No, but
Tennessee law.
you don't put your license on a real estate contract. You don't put your appraiser's license on a real estate contract. That is my argument why you
you're
don't
not
put your
rendering
license.
a
Yes,
value.
Sure you are. If you're doing a listing agreement, you are. You should, you're putting the listing amount on there.
It's a listing amount. There's a difference.
It's a value.
It's not appraisal.
No, it's not a value. It's not an opinion of value. There's a difference between, if you look at the definition, I've got a court case going on right now, a difference between price and value. There is a difference between price and value.
We had that same conversation with evaluations. An evaluation is an opinion. You're not doing an opinion of value on an evaluation.
But it's excluded.
Correct. That's why I don't think I feel like if you do that and you put your license number on the evaluation, you've made it an appraisal.
And if you don't put your license on there, you're misleading.
I disagree with that. And that's okay.
I don't. and we fought that battle a few years ago, and we have the FAQs.
Correct.
But moving forward on the reviews,
How many review complaints do we get? I mean, I don't recall any since I've been a member.
I think to Rex's point, I think that's coming. I think you're going to see in the next 18 to 24 months more of that pop up.
Right. So that was actually I had a conversation this morning. So because of the market, the real estate market is going the way it is, I'm pretty sure that we're going to have a large influx of appraiser related complaints coming in as well. So it was my understanding is that we were coming back to it. That we were not making a firm decision today, that I was going to provide you the information that's in the rules and in the statutes, and then we can look at that in January. But I do also think Commissioner Atwood wanted to know if anybody actually wanted to do that. Is that correct?
Yeah, I mean, yeah, I was just saying we go around saying, hey, do you want to do this? Do you want to pursue this or not? And if we do, if it's the majority wants to, then we should. My vote would be no.
I think it's worth us and maybe get about not putting it to bed, because I do think there's some gray area there, and it's important to.
I think anything you can make less gray will be better for the public and for the appraisers.
I agree to continue to.
I'm with Jim.
So I'll send you guys this information via email. And then in between now and the January.
Appraiser reviews. We'll keep independent appraiser reviews on the agenda under old business.
Very good. Thank you. That moves us to new business. We had one item shifted to new business having to do with short-term rentals, STRs. If we need to communicate to appraisers concerns about being qualified prior to accepting those assignments. And there's certain areas of the state where there are more STRs And the ones I saw came out of Gatlinburg. And
The issue that we've run into here locally is these short-term rental properties were in residential districts, and so they look like a house, and they were zoned residentially, but residential appraisers were appraising them, and the acquisition was for a entire business operation that the real estate was a part of. And so that is going to sunset in Davidson County in January. And so Davidson County is moving the short-term rental. It has to be in a commercial district, basically. And so I think that locally is some pretty good guidance on what type of properties these really are, that they're not residential properties. I see the biggest liability right now for not only the public secondary market and for residential appraisers is the valuation of these property types. And I think we absolutely need to provide some guidance on how we interpret it and our opinions of it. Just to, because I said a lot of appraisers don't know what they don't know, and it looks like a residential property, and they're doing them on these 1004s, and they're really holding themselves out.
Going to be any grandfathering in the new zoning?
There is, but the permits don't transfer, so you can continue to operate in certain zoning districts, but it doesn't transfer with a sale. So,
as long as you're the owner, but when you sell the property, it doesn't.
In certain residential.
We are currently dealing with a ridiculous amount of that in the Gatlinburg market, specifically where the property sales prices are unsustainable on when you're doing it on a 1004. People are trying to get it done on the secondary market with Fannie Mae and Freddie Mac because they can get better terms. And if anyone's paid any attention to the market out there, it doesn't seem sustainable in any stretch of the imagination. When properties have doubled in value in 12 and 18 months, the market doesn't exist that's actually what the value is. I mean, you can support it, I guess, on paper at the moment, but when the day of reckoning comes, there's going to be a lot of people very much upside down.
Except the problem with that is those values that are being supported, the real estate is only one component of that. You can have the management operations, because I'm a super host on one of these third-party websites and drive a higher income stream. That's not real estate specific, and yet these are all bundled together and sold and insured by the secondary market right now.
I also think that it's misleading to do these appraisals on URAR form, because Fannie and Freddie only want to make loans on residential owner occupied, or I guess they would make one on a monthly, normal type of rental lease, 1 year lease or something like that. But they're not going to make it on short-term rentals, overnight stuff. And if you don't note that in your appraisal, then you have been misleading.
That's what I've seen.
That's a huge violation right there.
Yeah.
How would we go about creating some FAQs, or as a commission, how does that process work?
We could easily make the changes to our webpage. Obviously, since it's forward or public facing, we would consult our not only our legal team, but our communications team as well, to make sure that our verbiage was okay, and it wasn't going to cause any problems. We weren't out of sync with any of the rules or regulations. But all we would really need is either we could discuss right now and we could come up with them on site, or we can try and come up with them on our own, but I feel like they may not be specific enough to what you're asking for. So if you want to put somebody in charge of it and they can send the submission to us, we can vet it and go through the process. We could bring it back to the next meeting in January and vote on them, which is kind of what I would prefer to do, just to make sure that everyone's on the same page.
I'd volunteer to create something and submit. for review.
Okay.
Thank you, sir.
Just have it back to me before the next meeting so I can include it with the meeting material.
Monday at 5 o'clock, right?
Correct.
With that, I will entertain a motion.
Well, I'm not through yet.
Oh, you're not through? Okay.
New business? Do we need to vote on, or are we just going to automatically be able to accept the AQB's change of policy to allow non-traditional clients for experience? That meaning I can take a trainee on, but all they're going to do is they're going to appraise their own house. They're going to appraise the next door neighbor's house. They're going to appraise the lady across the street. Whoever will let them appraise their home, and get 100% credit. It's already in place for 50% credit, but it's going to go to 100% credit on in January of next year. Do we need to vote on that, or are we just going to accept the AQB's change? I don't know what we have to do.
I think there's some other changes.
There are other changes other
Right,
than that.
right. How does that work in the past, as far as any changes with regard to qualifications? How do we automatically adopt? And if that's the case, PREA, when it comes into place, we automatically adopt what it says. But the AQB is only the minimum, and they emphasize this in DC. The AQB is just the minimum.
Right, and we have a statute that says we. I forgot what I was going to say.
Isn't there something that we can't then?
That's what I thought we had that conversation like a year ago.
That was with the education. We can be no more stringent than federal.
So what would happen typically is I think that we would adopt the minimum standards of the AQB. And then if we were to include additional standards to look for our specific jurisdiction, we would talk about those. But
In an example of where we have gone a little bit further than what the federal guidelines is the interview of the trainees. I think we're one of 2 states in the country that do the interview process. And I think everyone would agree that it is a good process. So as far as nitpick, I think we have to look for what's best for the state of Tennessee.
That only arises if someone files a complaint. I guess I'm just asking.
We can check.
Well, I still need clarification on, because I'm interviewing a trainee this afternoon, on the basis of the new AQB ruling. And I want to be sure that when she turns her experience in a year, and all it is her grandmother's house and her 3 rental properties, she's going to get all the 1,500 hours. That's not the point. But it's not going to be a lender. It's not going to be Fannie Mae. It's not going to be stuff like that. It's going to be individual homes that she has been able to come up with, that people will allow her to provide an appraisal under my jurisdiction. Under my supervision, of course, 100% under my supervision. But
she could make the property owner the client.
Well, I was going to ask too, who's the client? Well, you make the property owner the client, then I was wondering if you could just make the state of Tennessee or the appraisal commission, the client.
I don't
and
think that
intended
would-
use being for training purposes.
Yeah.
That's your opinion. Is
Yeah.
that
Yeah, that non-traditional, from my understanding, was more in an education setting. Like the class I teach now, they're working through an appraisal.
Yeah, but that's not the limit of it. No.
Yeah.
Like I say, she can, whoever will let her appraise their home, she can get credit for it. She can do a full appraisal on it and then get credit for it.
And the property owner could be the client.
Well, it could be, but it doesn't have to be. That's the clarification.
So you're just looking, you're looking for a way that she could do it, and that's a way she could do it.
To that end, just because I have a question now that Jim has brought that up, we have people in the training program at work, so I potentially could have them do standard 3 reviews for us, but it was not intended to go anywhere, just for our own internal use, up to 100%. I always knew it was 50, and we've done some of it, but now we could go up to 100%.
Going back many moons ago, when I was first licensed, I turned in some reviews because I was working for a lender. So yeah, standard 3, it would, and they would have to follow the same guidelines as an appraisal. But yeah.
Okay.
I think jumping out and doing one item, I think it would behoove us to wait and see everything with the AQB, any changes, and then cover that if any rules need to be changed. Would you agree?
I'm just trying to think, in what world would we not accept the minimum standards required by the AQB?
The only world that we decided to change that rule.
Right. But I just kind of see that as since we are federally regulated, we are required to accept certain things. So until we have further specifics, I don't see how we could just be we're not accepting the minimum. Does that make sense?
Get audited enough by them that we'll get, there's no, what Anna's saying is true. I mean, there's no way to justify that.
I don't see us in a world where we're oh, the AQB does not apply to us. So that's the only reason I'm thinking. But if I'm not thinking in kind of the method that we're talking about, please let me know.
At one time with Perea, it was a matter of accepting how much of that type of experience do you accept, 100%, 50%, because some states accepted only part of it.
Right.
Which the argument with it, what good is it if you don't accept 100% of it?
Right. And now we have further clarification on that, so we would adjust that as accordingly. But right now, I don't see the harm in moving forward with accepting the minimum standards. If rules need to be made to clarify that can be done. But I guess I don't see kind of where we can ignore the minimum standards. Does that sound correct?
Yes.
Okay.
To answer your
No, but I'm going to move forward with what I understand it to be.
It should. The answer is yes, until we move forward.
Do something different.
Well, here's the answer to your question. Right now, as of today, it's 50%. Are they going to do all 100% before the first of the year? Probably not. So you're good until the first of the year, and then it shifts to 100%.
Okay. That's what I want. Now, that's what I wanted to hear. That's what I believe to be the truth, but I wanted to hear somebody say it.
Well, Jim, if you wanted me to say that, you could have said that. You wanted me to say that.
Very good. I will entertain a motion.
Motion to adjourn.
Second.
If real quick, just before we do, I wanted to take a small, I should have had this in my report, but just a small moment to let you all know that we have a new staff member, Sharita Brown, who's in the back of the room here. This is her first day with us. She has been, is becoming part of the team as an admin 3. She's going to be handling a lot of things that surround board logistics and meetings and, things like that, some of the things that Morgan has previously been doing for us. She's also going to be covering a lot of processing items as needed. And to give you all kind of a heads up on where we are, Caleb is now the sole manager of all the 6 programs that fall under my area. So we've now blended in the architects and engineers program on top of the other 5 that Caleb was already managing. So he's going to have a little bit of a workload. There's going to be a little bit more of incorporation of some other staff members moving forward, but I just wanted to give you all a heads up on that so that you weren't kind of surprised when you saw a new name or 2 pop up with a request. So, and that's it. Sorry.
From the legal side, Erica's term with us, she was filling in until we got a permanent member. And we thank her very much for the work that she has done. So moving forward after Erica, the disciplinary counsel for this program is going to be Miss Taylor Hilton, and she's seated right there. So you're still stuck with me.
But if you have any questions for these new folks, just fire away. Don't bother letting us know. Just get at them. Get right at them. Yeah. No, that's welcome to both of you, and we look forward to working with you. And after that, I think there's been a second on the motion to adjourn.
There was a motion and a second. All those in favor, say
Aye.
Aye. Aye. Those opposed, like sign. Meeting adjourned.
Thank you all.
If you want all your monies.